Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because they agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifted. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as Your Law Intellect. Welcome. If you are new here, I want to personally welcome you. If you could consider subscribing to the channel, make sure you all hit the like button on the way in if you have not done so already. But I know you guys know YouTube etiquette, so you probably already done that, and I appreciate it. Thank you so much, Brina1971, for becoming a YouTube member. I appreciate that so very much. All right, you guys know why we're here. We are here because y'all thought it was over. You thought Diddy wasn't going to still fight to get out. So if you guys have been following the platform, we've been following the Sean Diddy Combs case since he was arrested back in, I think it was September of 2024. There have been a lot of motions filed here and there. At the beginning, there was a lot of tussling about him getting out on bail pending trial. After a while, after filing motion after motion, the judge was like, no. The original magistrate said no. Then the judge said no. Then they appealed it to the Court of Appeals. And then suddenly they was like, forget it. Forget it. Diddy just said, I'm going to stay here and keep eating these honey buns and this nasty cheese and these bologna sandwiches. Forget it. You're not going to let me out. Bump it. I'm just going to chill here with my bunkie until the time comes. Okay, so he chilled and they started, getting back and forth about other issues. So he stayed over there in that facility that, by the way, has a whole lot of articles about how disgusting it is and some alleged violations, just all type of stuff going on in that facility. Because that was one of the reasons why when I was covering Lamar Whitehead, why he was trying to get up out of there. Okay, he was trying to get out of there talking about, it got to a point at that facility where judges are not even, if they knew they were going to that facility, they would find ways to if they could, for them to be out on bond. So, anyways, hold on. So, excuse me. I'm just giving a little background. So now what ended up happening is that Diddy, again, once he was acquitted of the major charges, as he should have, he was asking to be out on bond pending the sentencing, because there's a potential that he will get probation or he will get time served because he had already done all of those months because he was convicted under the Mann Act. All right. You guys following me so far? So now, after Diddy, the judge was like, no, absolutely not. I'm not letting you out. So, all the people that hate his guts online were like, yes, I can sleep better now because Diddy's not getting out and all of that. And so it appeared that Diddy was just going to say, forget it. I'll just wait till October 3rd. Well, it looks like perhaps his attorneys was like, okay, we just going to sit around. We're going to sit and we're going to figure this out and figure the best way that we may be able to get him out and perhaps put it in a position where we can try to do an appeal with a better record. Okay, that's what it's looking like. So now today they have filed a motion. A couple of you guys did DM me about this. I was in court today And so I made sure and went online or whatever and pulled it as well. He has filed a motion for bond is what we are going to be going over. So sit tight. Hope you guys are able to listen to the entire live. And also, if you are on the replay, welcome to the replay as well. Let's see. Yolanda, hey, good to see you. TLC is necessary. Hey, good to see you. Brina said, I am sure the judge is rolling his eyes about Diddy, shaking my head. Well, what I will say about that, Brina, and everybody can have their opinions. What I will say is the judge was very specific, and I pay attention to what is being said, maybe read between the lines as well. The judge said, I need sentencing or I need opinions from the courts on both sides, of which a judge has basically given what you're asking Diddy as a sentencing. And I want the prosecutors to do the same thing. Now, the prosecutors, when they were asked on the spot about it, they didn't have any cases. They mentioned something about minors, which we know he was not convicted of. But I guess I'm sure they're going to do some type of research, and that research will probably be more than just appellate cases. It will probably be jurisdictional cases within that district court, and try to see how other judges, so that they can support what they are asking for. What the government is trying to do is find ways to enhance his sentencing to make it greater, to make it greater than what it would originally be under the sentencing guidelines. And what, of course, the defense is doing is they're trying to mitigate to make it lower. And so you're going to see competing memos related to both as far as the guidelines. So, yeah. Lindell said Maureen Comey isn't even around anymore. Let the man go. He is. She's gone. She's gone. People have speculated. Some people didn't know why she was still there. Because, the president, Mr. President of this here divided states of America, has said that he doesn't like her daddy. So they were wondering why he allowed her to be on there as long as he was. Do I think it necessarily has anything to do with Diddy per se? Some people are saying it is. I don't know. But yeah, she was definitely fat. Yes, Tiffany. Thank you so much. Grace, Mercy, and Save said, I guess it can't hurt to keep asking. As long as you got something to back it up, why not? Nothing beats a failure but a try. And that's what I used to tell people all the time. The only thing they can do is say no. But if you don't ask, they can't even say that. So, listen. So, anyway, let's pull it up. Make sure y'all hit the like button so all of the other intellects know that we're on, and maybe some future intellects can know that we even exist if y'all hit that like button. Okay. Now, some people don't have any hope in this because the judge seems a bit, he kind of let us know how he feels about this thing. So this is the motion. Again, it was filed July 29th. Dear Judge Sub Bermanian, Sean Combs released on appropriate conditions in advance of his sentencing hearing scheduled for October 3rd, 2025. And that again may be why, instead of trying to get the earlier dates of September or whatever, why he was like, just keep October, because there was discussion about them filing this and perhaps he can get out. And the closer it comes to it, then maybe it would seem moot and to file something like this because he's about to get sentenced anyway. So the further out the sentencing is, the more that this memo would make sense. So it has Title 18 USC Section 3145C gives the district court the authority to release a person otherwise subject to detention pursuant to Section 3143 sub A sub 2, where among other things, quote, it is certainly shown that there are exceptional reasons why such person's detention would not be appropriate. And that's over there at US v. Chavez. If you guys are just that interested, could double check their quotes. Okay. There are exceptional circumstances warranting a departure from the mandatory detention and ensuring that Sean Combs is released. So that is one of the issues they had, is that there is mandatory detention based on what he was charged with. and they didn't have any exceptional circumstances that they argue. So they need to sit back and go to the drawing board and find some exceptional circumstances. First, as shown below, the history of the Mann Act, and we all know the history, it's very racist, as well as how it has been prosecuted over the last several decades, clearly indicate the exceptional, indeed unique nature of this case, specifically the prosecution and continued incarceration of a customer of services provided by an ex-worker to a third person, rather than of a defendant profiting financially from the business of prostitution. And I think this is the issue that a lot of people have. They're like, okay, Diddy may have paid, but he was just over in the corner watching. And he didn't get paid in order to have Cassie out there, but he was paying people, or Cassie and whoever, but he was paying people. And so this is not even what the intent is. And this is not typically, when you look at the cases, this is not what you would charge somebody with that is in this situation that Diddy is. In the limited cases of Mann Act convictions from across the country that bear any similarity to Mr. Combs' case, the defendants were released pending sentencing. So they've scoured the whole United States federal courts and said those that are even remotely similar, which means the most probably weren't any that they found that were spot on, but those that are kind of similar, just a little bit, they got out released pending sentencing. Second, Mr. Combs' conditions of confinement of the MDC qualify as exceptional circumstances as well. So, to be released on conditions under Section 3145C, two conditions must be met. First, the district court must find by clear and convincing evidence that the person is not likely to flee or pose a danger to the safety of any other person or the community if released. Now, that is something that the judge kind of hinged his opinion on. He said, listen, I get it. The strategy was to concede because you cannot deny this tape of you and this altercation with Cassie when you was kicking her and all of that stuff on tape. So he admitted a violence. And so the judge, you basically said you violent. So why should I put you in the community? And you basically said you was violent. And then subsequent to that, there were people, I guess, that allegedly testified to experiencing some of the violence or whatnot. So that was part of what the premise was on, that the judge made his decision. Second, it must be clearly shown that there are exceptional reasons why such person's detention would not be appropriate. We will first address the exceptional reasons justifying Mr. Combs' release and then turn the set of proposed conditions that will assure Mr. Combs' return to court and ensure the safety of the community. These are the exceptional reasons to this case that justify release according to his attorneys. As noted, there are several exceptional reasons justifying release. First, in the history of the statute, the Mann Act has never been applied to facts similar to these to prosecute or incarcerate any other person. Second, in any somewhat similarly situated cases to this one, all the defendants were released pending sentencing. Mr. Combs' conditions of confinement at the MDC for the past 11 months justify release. As Judge Furman noted in Chavez, the Supreme Court has never addressed the meaning of the exceptional reason provision, and the Second Circuit has addressed it only sparingly. The provision was first addressed by the Second Circuit in U.S. v. DeSoma, and that's over there in the Second Circuit 1991 case, where the court observed, quote, neither that statute nor case law defines the circumstances which may qualify as exceptional reasons permitting release, and that the legislative history on the issue is sparse and uninformative. The court further stated that, quote, a case-by-case evaluation is essential, and it is not our intention to foreclose district judges from the full exercise of discretion in these matters, end quote. The U.S. v. Lay decision gives a trial court, quote, wide latitude to determine whether a particular set of circumstances qualifies as exceptional. The circumstances here are by definition exceptional in that there has never been a Mann Act prosecution remotely like this one. Clearly, this is precisely the type of exception that the court in lay was contemplating when it gave this wide latitude to the trial court. The Chavez decision further noted that the circuit's only other published decision addressing the meaning of exceptional reasons is in U.S. v. DeSoma. There, the district court found exceptional circumstances because the defendant was a student enrolled in community college, was employed full time, and had no prior convictions. The Court of Appeals found this was a clearly erroneous interpretation of exceptional reasons, noting that the test under Section 3145C is necessarily a flexible one, and district courts have wide latitude to determine whether a particular set of circumstances qualifies as exceptional. The Court of Appeals found, however, that there was nothing exceptional about attending school or being a first-time offender. Similarly, in the unpublished decision of United States v. Colon, that means when it's unpublished, it's more persuasive. It's not binding, it's just persuasive on the court. The court can choose whether to consider it or not. But when you have a published decision, that means it's binding on the court, and the court is supposed to adhere to that decision. The court observed that supporting one's family, being employed, and complying with the conditions of supervision are likewise not exceptional reasons for release. The proffered reasons here, specifically the exceptional nature of prosecuting and incarcerating a person convicted of paying for X services to be provided to his girlfriend, as well as the exceptional circumstance facing Mr. Combs at the MDC, given the truly unique circumstances of this case, are specifically the type of exceptional reasons that justify release under Section 3145C. Far from being routine basis typically of many defendants, the reasons here present unique circumstances that are found in virtually no other cases. We address the exceptional reasons in turn. That wasn't like it. Y'all got more to say? Okay. So now make sure y'all hit the like button, please. Thank you so much. So Tyrone said free Diddy and get rid of the Mann Act. Okay. The Mann Act is a special type of document, just like a lot of the documents in this here United States of America. Grace Mercy said let Diddy out for some fresh air. Child, he may go in the yard. They might let him go in the yard. What you think? Or is he in some type of protective custody or something? I don't know. But let's see. Because I want you all to tell me if you think, because the facts are very unique. But see what happens, and this is what I was saying with RICO, why some things turn into slippery slopes. You can look at the historical, and because I do this, I do it all the time, where I look at the historical reasons behind certain statutes. When you look at the historical reasons, most of the time you try to press just for that historical reason, especially if those facts don't match your facts of your case. But what'll happen is, because the way it's drafted generally, even though it may be a specific incident as to why this statute was addressed, just like the RICO statute was mainly for mafia. They couldn't get the top boss because they wasn't the one doing anything. So they said a whole enterprise, anybody do it at your command, and y'all all got the same purpose for the enterprise and all of that, then you going down too. So we all know what's behind that. But then you extend it, because the way it was drafted, to say, well, we can say you did this, and two. Everyone else doesn't have to know what everyone else is doing. We're going to create that it was an illegal enterprise, and now we're going to get you. So how far are we going to go with it? Same thing with the Mann Act. When you clearly look at it, one of the things I said was, if the jury just looks at the black letter of that document, they're going to convict them. I told you guys that. I maintained that from the beginning. And that's pretty much what happened if you look at it. But how we know prostitution to be is you sell your body for sex. That's how we know prostitution to be. We've never seen it where someone hires someone to come in as an escort. They end up having relations, and then it was a relationship as you're a third party paying someone, but the person that actually was engaged in it, who you guys are saying is the prostitute, they don't even get convicted. They didn't get convicted of anything. Just the person who paid for them was sitting there watching it. So it is, they're saying it's a unique situation, which it is. But if you look at the black and white of the statute, paying somebody to engage, you cross the lines, whatever it is. And it was like, okay, well, if you look at the black and white of it, in theory, I guess they can try to say that it fit. But we all know that that's not really how we view prostitution. I'm just saying. All right, let me get one more of your comments, and I'm gonna go back and read. Belzani said all these New York jails are damn near uninhabitable. They'll be doing a lot of early release from Rikers. Well, I'm not understanding. There is something called an eighth. You have an Eighth Amendment right, cruel and unusual punishment under the Constitution. And my thing is this. What can happen and what has happened in other cases if when you have people that go hard enough against these prisons, and I know a lot of those prisons have been under what I call consent agreements where the courts will give them a certain amount of time to get it together. You can request an injunction and they got to shut that joint down. That has happened in a couple of prisons, or they got to move them all to other facilities, but it depends on how hard you go. Our women's facility in Michigan, we only have one. It's a big story out there of people getting sick because of the mold. They have a bad case of black mold. There's literally a class action now, and the court has basically disallowed an early dismissal, saying that this can be in a situation of which is a constitutional violation. But that's money damages and all of that can occur, or they'll try to shut down the facility and take them to another facility. But in our facility here, we've had women who actually, it was one woman who, when she died, she was on chemo, getting chemo for cancer, and it was mold in her port, like connecting. It was mold growing in her port. It's another young lady named Crystal, and that's the same thing. They said she got mold growing out of her ear. She has an allergy to it. So now she basically has mold in her body. They still ain't shut down that facility here. So what the bar is for them to shut it down, I don't know. That's not really my area. I want to save everybody and save the world, but I'm just one person, so I can't. But yeah, so it's not uncommon that and some people don't care. And I think the reason why they don't care is they feel like you're in prison for a reason, and it ain't I've heard people say this is not a resort, and so they don't care. But there are some people that are in there and they have out dates, and they don't make it to them out dates because you get sick while you're in there. And inhumane, they're still human beings, regardless to what they're in there for. Even if they're in there for the rest of their life because they have a heinous crime, they still are human beings, and they do have rights under the Constitution as well. But it's about who's going to go hard for prisoners. Who's going to really go hard for the prisoners? You got ACLU, you got some civil rights unions, other civil rights entities that have tried to, fight. I see a lot of people around here that's been fighting for our facility here for the women, but who is really putting that behind and feel like the masses really care about people in prison? Because some people really believe everybody in prison did what they said they did and don't believe that prosecutors wrongfully convict people or that they make mistakes. So yeah. TJ said the prison workers be suing too. Yeah, there's been prison workers I know here who have come and they were like COs, and they said they developed asthma when they were working there. Like they're susceptible to the same thing that the prisoners are. Yeah. Yep, Mr. Big Playboy sure is. All right, let's move on because I could talk about that forever. So these are the underlying facts make the prosecution and continued incarceration exceptional. I want you guys to just listen, and then you can say whether you agree or not. Let me make that a little bit bigger for y'all. For y'all that wear glasses like me. Okay. The prosecution and continued incarceration of Sean Combs are unique in the history of the Mann Act. There has literally never been a case like this one. where a person and his girlfriend arranged for adult men to have consensual sexual relationships with the adult long-term girlfriend as part of a demonstrated swingers lifestyle and has been prosecuted and incarcerated under the Mann Act. Combs and two of his longtime girlfriends had a private, intimate life that is not uncommon today. It may not have been common on June 25th, 1910, when the Mann Act, or as it was originally called, the White Slave Traffic Act, that is what the original name was, guys, was passed. But attitudes about sex and morality have come a long way in the last 115 years. It is worth noting that when the Mann Act was passed to protect the morals and decency of America's women were not allowed to vote. Yes, we were property at that time. We were property. As noted below, perhaps due to the troubling background of this statute, whose history is rich with both racism and misogyny, the Department of Justice has limited its application to those people profiting financially from the business of prostitution and not using it to prosecute consensual adults for their own lifestyles. Cassie Ventura and Sean Combs went to swingers clubs and they had threesomes. Miss Ventura consistently expressed interest and enthusiasm in her intimate life with Combs, including what they called freak-offs. Jane and Sean Combs had threesome too. When Jane and Combs watched pornography together, Jane testified that she contacted two different porn stars and invited them to join her and Mr. Combs. Both Miss Ventura and Jane testified that very often they would see the same men over and over again for years. In July of 2024, Jane testified, for instance, that she suggested to Mr. Combs that they call Paul. Jane explained that she told Combs she missed Paul. When asked why she said that, she responded, "Because I did." This was a lifestyle, one that both Miss Ventura and Jane chose, one they all, as grown adults, had a right to choose. Like many aspects of sex and intimacy, it was not without its complications, its bouts of jealousy, and at times its frustrations. But that is a hallmark of any serious romantic relationship, and that is what these were: serious, long-term romantic relationships. A jury listened closely to all the evidence concerning these two relationships at the center of this sprawling racketeering conspiracy indictment, and the jury acquitted Mr. Combs of all of the serious counts and almost all of the conduct charged. The jury concluded that Miss Ventura and Jane were not forced, coerced, or defrauded into having commercial sex, but it did conclude that there was prostitution, that the payment for the cowboys for angels, the porn stars, and others amounted to sex for money, despite what the only two escorts called by the government testified. In the lifestyle that he and other adults voluntarily chose, Mr. Combs would be called a swinger, but in the vocabulary of the Mann Act or of prostitution generally, he might at worst be somewhat analogous to a John, someone who pays to have sex with a sex worker. In this case, a male sex worker, more particularly a male sex worker who works for and is vetted by a well-known agency called Cowboys for Angels, or another similar agency, or who works as a paid porn star in connection with movies. Sean Combs should not be in jail for this conduct. In fact, he may be the only person currently in the United States jail for being any sort of John, and certainly the only person in jail for hiring adult male escorts for him and his girlfriend when he did not even have sex with the escort himself. Over the last 75 years, the White Slave Traffic Act has been limited to defendants who cause interstate travel for financial gain through the business of prostitution, as reflected in the cases brought under the statute, as well as the explicit enforcement policies set out in the United States Attorney Manual, more recently called the Justice Manual. That Sean Combs remains in jail for being convicted of being a customer of consensual adult services makes this case truly exceptional under Section 3145C. Not only is prosecuting the users of adult prostitution services inconsistent with the Mann Act, it's Oh, they put the it is together. It is inconsistent with the prosecution policies of the district attorneys of Manhattan and the city attorneys of Los Angeles, California, two of the three locations where this prostitution allegedly took place. In addition, Mr. Combs is incarcerated while everyone else involved in the identical conduct, his girlfriends, the cowboys, the agency's leaders, the porn stars, and others, walk free, as they should. If there was ever a fact pattern that was exceptional under the Mann Act, it is this one. As a result, this court should release him on reasonable conditions in advance of sentencing scheduled for October 3rd, 2025. This fundamental factual distinction between the current case and the scores of other Mann Act and prostitution case makes this case exceptional under lay. Do you believe, and they're going to go over like what I guess the Department of Justice says next. So do you all believe that they have a point? Huh? Tyrone Weather said, what is your take on the prostitute suing Cassie? I mean, he can sue if he want to sue. I don't know. I don't really have a take. That's his prerogative. I think it's going to open up a lot of cans of worms. And I think if he would have came before, just like the Jonathan Oddie, he probably seen how much, once he seen how much Jonathan Oddie got, or Odie, or whatever his name is, which was allegedly, I guess, $5 million. Of course he gonna come. Then you see Cassie done walked away with 30 million, saying how Diddy treated her, and he was, and that was supposed to be against the law, and she was able to get money, and then he had the same relations with her. You know what I'm saying? Yeah, I mean, I'm surprised he's the only one that came forward as of now. But that doesn't mean that other people may have settled as well in the past. I don't know. Danielle said he's a John, but they positioned him as a pimp. Lindell said the Elliot Spurzer incident, I don't know how to say his name, sorry, is going to become a major problem with denying him bail. These prosecutors are in trouble big time. Okay. Thank you so much for your comment. So let's see what the actual Department of Justice policy is. So they don't pull it in the policy. They have a whole lot of footnotes. We're not going through all of those footnotes, but we will go through this. It has been the explicit policy of the U.S. Department of Justice to charge the Mann Act in adult prostitution cases only where the defendant is motivated by commercial gain. See, that alone, if that's the case, they probably shouldn't have brought it. For over 75 years, the Department of Justice has made clear through its own enforcement policies that Mann Act enforcement should be limited to cases targeting defendants who violated statute for commercial gain. Oh, wow. So they have footnote 6 is the archived version of the U.S. Attorney Manual. The white slave, for example, in 1953 version of the U.S. Attorney's Manual stated, the White Slave Traffic Act makes it an offense knowingly to transport any woman or girl in interstate or foreign commerce or in the District of Columbia or any territory or possession of the United States for the purpose of prostitution, debauchery, or for any other immoral purpose. Commercialism is not essential to a violation of the act. However, as a general rule, prosecution should not be instituted in the so-called non-commercial cases. As a guide to the exercise of sound discretion in non-commercial cases, consideration may be given to prosecution in such cases as the fraudulent overreaching of previously chaste young women or girls, or cases where state laws are inadequate involving married women with young children who are living with their husbands. Cases having the appearance of blackmail should, as far as possible, be avoided. That's interesting. What does footnote 7 say? Oh, it's talking about the manual, referring to the manual. The policy of not prosecuting non-commercial cases continued through the remainder of the 1900s until the focus of the statute turned to cases involving minors and or sex trafficking in the 1980s, as discussed below. Thus, the 1961 U.S. Attorney's Manual stated that, quote, prosecution of persons who are not engaged in commercial prostitution enterprises as panderers, operators of houses of prostitution, or call girl operations, and those who act for or in association with such persons should not be instituted without prior approval of the criminal division. The 1970 and 1984 manual stated the same. Well, I mean, the thing about this is we know that the former Damian Williams is the one that brought this case. So I'm assuming that it was some type of approval. By 1988, enforcement priority shifted to cases involving sex trafficking and minors, yet non-commercial cases remain deprioritized. That's what I was saying. Sometimes the history will help you with your arguments when you look at it. And that's what they're doing. They're going back through the history to see what was the actual purpose. Let's just get back to the crux of this. Yes, times change, and you have to kind of upgrade your laws to deal with the times, just like how a lot of states have decriminalized marijuana because heck, they like everybody is smoking it. They even use it for medicinal reasons as well. So that was one of the reasons why they like, okay, listen, we just gonna have a bunch of weed heads in prison if we just don't decriminalize some of this. So as times change, sometimes they do change. Now it looks like with this, perhaps because of the generalization, what they call debauchery and demoralization were things such as a black man who decides to get a white girlfriend and crosses lines and then has sex in that state, or a black man who gets a white woman, crosses lines, and then, or married, they might be married. They go cross lines and they go to a state of which it is illegal at that time. Remember before the Loving case, it was illegal to have interracial marriages. So because of that, then that would fall up under that, like debauchery and immoral purposes. You know what I'm saying? So it was the times. And so what they are arguing, it sounds like, is y'all need to get with the times, okay? Folks got swinger clubs. People are doing all type things that people are defining their marriages and their relationships. You got people like Neo talking about, I got 3 girlfriends. We got sister wives where they on TV and they all done broke up now. But y'all get what I'm saying. Origination. We got people on TikTok talking about all 7 of us live together and we all pregnant at the same time. You know, like it's just a whole different era of where women are down for the ish, just like some men is down for the ish. This is just a new time. You know what I'm saying? So yeah. Hey, good to see you. So let's go on. So it says by 1988, enforcement priority shifted to cases involving ex-trafficking and minors, yet non-commercial cases remain deprioritized. Unless minors are victims, prosecution under 18 U.S.C. section 2421 and 2422 should generally be limited to persons engaged in commercial prostitution activities, even though commerciality is not an element of the offense. And the same thing in Commonality v. United States, prosecution of persons other than those engaged in commercial prostitution enterprises as panderers, operators of houses of prostitution, or call girl operation, and those acting for or in association with such persons should not be instituted without consultation with the general litigation and legal advice section unless minors are victims. So they're saying and minors became priority, that they were worried about them prostituting minors. So that is what they used for that statute. Then the directive continued through the most recent iteration of the U.S. Attorney's Manual. Let's see. And today, the Justice Manual, which replaced the U.S. Attorney's Manual in 2018, makes clear that the prosecution of customers involved in an 18 U.S.C. Section 2421 offense, like Mr. Combs here, is now limited to, quote, prosecuting those who engage in commercial sex with victims of sex trafficking, in addition to those who otherwise perpetrate or facilitate human trafficking offenses. In the absence of any sex trafficking charge, however, it is clear that the standalone Mann Act counts never would have been prosecuted. So what he is saying is that according to the manual, the reason why they were able to bring it was because they also were alleging sex trafficking. And the way the manual is written for the U.S. Attorney's Office, that they go by, their own specific personal manual that decides what they're going to bring charges and what charges they're going to bring. You don't bring this type of charge unless there's sex trafficking. So that's why they brought them together. So they probably would not have brought it just separately if they didn't think if they couldn't do sex trafficking, the RICO, whatever. They probably would have never brought this specific charge as a standalone by itself. It comes as a package with sex trafficking, and that's what makes it okay in the U.S. Attorney's Manual in 2018. Historically, the punishment for non-commercial Mann Act violations was similarly limited and restrained. Prior to the creation of the sentencing guidelines, the U.S. Parole Commission rated non-commercial prostitution offenses under the Mann Act as to be a Category 1 offense, the lowest severity level, warranting, quote, customary total time to be served prior to release of less than 6 months to 12 months for very good and fair defendant score, and time up to 16 months only for poor defendant scores. And when the sentencing guidelines were first created, the Mann Act guidelines under Section 2G1.1 provided a base offense level of 14, which, in accordance with longstanding DOJ enforcement policy, assumed that the offense was committed for profit. It further provided, in the infrequent case where the defendant did not commit the offense for profit and the offense did not involve physical force or coercion, the commission recommended a downward departure of 8 levels. That application note was enforced through 1995 sentencing guidelines until the Amendment 538 removed the application note for non-substantive reasons as part of consolidations of Section 2G 1.1. So we basically going back down memory lane, okay, on the guidelines when it comes to the Mann Act. In sum, so they wrapping this all up in a bow. In sum, for over 75 years, the Mann Act enforcement has been limited to cases entirely distinguishable from the instant offense of conviction for merely paying for a person to have sex with others, and intentionally so giving DOJ's explicit instructions to avoid prosecuting offenses like the instant offense of conviction. For example, the only modern era prosecution of Johns that we have identified involved defendants who patronized prostitutes who were vulnerable immigrants with limited English language skills who were being trafficked by brothel owners. And these cases, unlike here, did not involve defendants who paid a person but did not himself have sex with the person. Regardless, the penalties for such offenses were typically less punitive than the prison time Mr. Combs has already served. Consistent with Justice Department policy, Mann Act cases in recent years are focused on defendants profiting from the business of prostitution. So now they're coming up with the cases that, I guess the judge was requesting. All right, make sure y'all hit that like button, okay? Hey, Linda, good to see you. TJ said, why wouldn't it just be soliciting prostitution? Because they're, generally speaking, that's kind of what they are saying based on the statute. But that is not what it was meant for. So they're just going down the historical pattern. And then according to the U.S. attorneys, because they have their own guides on bringing cases, what to bring, when they should bring them, and what circumstances, what factual basis they should bring them on. They only bring this when there's sex trafficking, when it's not commercial or doesn't have anything to do with minors. So that's kind of their own, I guess, guidelines and guide points. So yeah. Any other questions? Dev said the world saw that the feds trumped up his charges, but absolutely failed. Yeah, they definitely. Thank you, Stace. They absolutely fumbled the ball on that one. Arrest said that's a really good point, Danielle. He definitely treated him and want to punish him as a pimp. Okay, Elliot. Okay, hold on 1 second. Elliot Spitzer. Okay. What happened with him? Let's see. Oh, they got books on the rise and fall. So I feel like I heard this before. I think I've heard this. When he have like a prostitution scandal or something. Okay. On March 10th, the New York Times reported that Elliot Spitzer, governor of New York, had patronized a prostitution ring run by an escort agency known as Emperor's Club VIP. During the course of an investigation to the escort agency, the federal government became aware of Spitzer's involvement with prostitutes due to a wiretap. Following the public disclosure of his actions, Spitzer resigned as governor effective March 17th of 2018. So they got the alleged clients. Let me see. You want to see what he got? Oh, they got a whole little dissertation on this. Okay. Became international news. Political impact. Was he charged with something? Hold on. Escort boss and Spitzer gets prison. Oh, no federal charges against him. Ooh. Elliot Spitzer will not face criminal charges for patronizing a high-priced prostitution ring, federal prosecutors announced on Thursday. Oh, my. Well, there goes that question. Let's see what ABC News said. Federal prosecutors said today they will not bring criminal charges against former New York governor for his involvement as client number 9 on an international prostitution service. Spitzer resigned as governor on March 12th after it was read. Well, that's probably what they told him. If you resign, then we won't bring charges. The governor's sex scandal was front page news around the world as he announced the shame and resignation with his wife, Silda, standing by his side. She a good one because you gonna stand up by yourself for this one, bro. She remains married to Spitzer, and they have been seen walking hand in hand in the Upper East Side Manhattan neighborhood. I appreciate the impartiality and thoroughness of the investigation by the U.S. Attorney's Office, and I acknowledge and accept responsibility for the conduct it disclosed, Spitzer said in a statement today. I resign my position as governor because I recognize that conduct was unworthy of an elected official. Well, there's that. Hey, Golden, good to see you. No, has on there they didn't charge us. No, he was never charged. Yeah. Cassandra said, I think the judge and government is treading lightly since Comey was fired and they are staying within the guidelines. Do you think it's going to change their mind? I think it is going to affect how hard they go. And I also think that this is a case that Trump would consider. And that's because of some of the allegations people have made against him. I think that it's a case that he may consider. So, Anthony Weiner did time. All right. The prosecution by the U.S. Attorney's Office and the District Court within the Second Circuit have, as expected, followed the directives provided by the Department of Justice in the Southern District of New York cases such as, I'm not reading all those, but y'all see all those cases. You see that? They said the U.S. Attorney's Office and the District Courts within the Second Circuit, they done followed the directives of the DOJ in all these cases. You see them? Each involved defendants who developed and or maintained prostitution businesses to make a financial profit. Defendants who developed and or maintained prostitution businesses to make a financial profit. The common element to these cases is a clear financial motive on the part of the defendant. In some of these cases, such as Hernandez Valquez, the prostitution businesses involve well-organized trafficking organizations which smuggled poor, vulnerable young women from another country to the U.S. to work in brothels while the organization took the lion's share of the profit. Yeah, that is horrible. They have all these cases in the Eastern District of New York. And they say likewise involved defendants who operated prostitution businesses for profit. Several of these cases also involve the prostitution businesses moving women from another country to the U.S. and taking advantage of the women's immigration status. In U.S. v. Jacob, the defendant had a long-term relationship with a 15-year-old girl. So while Daskal was not motivated by profit, the victim in the case was a child. So they went through all the cases. Like, listen. Of the district courts within the Second Circuit, the only case located to date by the defense where a John was prosecuted under the Mann Act in an adult prostitution case was from the Western District of New York in the case of U.S. v. Trowbridge, which is a 2008 case, where the defendant, and it's not in a court of appeals, it was actually a district court case in the Western District of New York, where the defendant was a retired police officer who, along with a former New York State judge, Tills, and others, hired women who they paid to have sex with members of a male fraternal group called the Jesters. Although Tills and Trowbridge apparently made no financial profit and were merely having sex with the prostitutes and arranging for others to have sex with them, unlike the male escorts in this case, the female prostitutes being patronized by these defendants were clearly victims of sex trafficking. The victims were vulnerable and exploited by traffickers. They had been tricked into working for a brothel by the owner, who had told them they would be providing normal massages rather than sexual services. Indeed, the owner pled guilty to sex trafficking and admitted, quote, preying upon financial and ethnic vulnerabilities, immigration statuses, and using her relationships with public officials, including the police officer and the judge, to coerce the woman to engage in commercial sex acts for her business. And then they direct us to U.S. v. Chong, and they're describing this is what was said in a factual basis because she pled guilty. And so this is what was alleged in that factual basis, what I just read. That's supposed to be the reason. The police officer defendant, Trowbridge, was sentenced to probation. The retired judge, Tills, who arranged the prostitution activities for the Jesters, was sentenced to 18 months in prison. Although they did not make a profit, the Trowbridge defendants, unlike Mr. Combs, were taking advantage of trafficking victims, and they all had sex with the prostitutes. And in another Western District case, U.S. v. McDonald, the defendant, who was also charged with sex trafficking, operated a prostitution business and brought 4 different women around the country to engage in sex acts for profit. In the District of Connecticut cases such as U.S. v. Briggs and U.S. v. Paris, which is a 2006 case, Briggs is a 2011 case, each involved prostitution businesses for profit. These cases illustrate that, with rare exceptions involving female prostitutes who are exploited and trafficked, every defendant prosecuted under the Mann Act was involved in building or maintaining a prostitution business for profit. The cases reflect the directive in the U.S. Attorney Manual and Justice Manual that the Mann Act be reserved for cases involving making profit from the business of prostitution or some form of coercion. The non-exhaustive review of cases, as well as the policy of the DOJ, show the exceptional nature of the facts here, where Mr. Combs pursued a consensual lifestyle with 2 of his long-term girlfriends and obviously was not involved in making a profit from prostitution, which was not even alleged by the government. Okay, so what do you guys think? What do you guys think? Jam said, let him wait until sentencing. He should not be on the loose. It's Mimi said, I just want to know what's the difference between the allegations against Diddy and those against rapper Cash Out. I didn't watch the Cash Out trial, so I have no clue, unfortunately. Classy said, meanwhile, Mike Jeffries is home on bail with 46. Well, he's actually not at home anymore, Classy. He's been deemed incompetent. So he is away at a facility. And if he is not deemed competent in the next 90 days, they're going to have to drop the charges. But yes, he was originally out on bond, and he was in a whole nother state when it started out with Jeffries. He was in Florida. They allowed him to turn himself into Florida, but the charges were out of the Eastern District, I think, of New York. He flew in. They was like, okay, you got the money. All right. And they let him out on bond. Then when he went back, his lawyer was alleging, same thing that I think Tom Girardi tried to do, but it ain't work for Tom Girardi. They was like, you are sane and you will be standing trial. We don't care. Your dementia's not that bad. And so he's over there about to spend the rest of his life over there in the prisons in California. Unless he wins on an appeal or something else happens. Or he gets pardoned or something. Yep, I heard Classy said he's not incompetent. Well, that's what they said. Okay, so they're going to take him. That's what insanity is. That's the difference between one of the reasons why they've added guilty but mentally ill is because you have, I think it was Reagan, the person who tried to unalive Reagan was deemed insane. And then once you're deemed sane, like say for instance, they say insanity. And then once you're deemed sane after you're guilty by reason of insanity, you go to a facility. And then once you're deemed sane, they let you go home. Because you was insane at the time, so you didn't have the competence for it. Now they did the guilty, but mentally ill. I know they have that here. It's because basically you guilty of everything they said you did, but you gonna go to this here Michigan Department of Corrections, and we're gonna give you some classes, and we're gonna give you some psychiatric care. And so when you're guilty of that, they have to give you the mental health care that you need. So some people think when they was pleading to that they were going to be some leniency, but no, you just basically saying you did it and you going to hit your guidelines, and they say they're going to give you help when they're in there. Now, if they do that, I don't know if they actually do give you help, but I mean, you talking about facilities where they got mold all up in them. So I don't know. But that's like what it is with insanity. Now, if you're deemed incompetent to testify, you can't even testify if you want to. You don't really know what's going on. So you're deemed incompetent before anything happens. Then they try to take you to a facility. They'll stay your case. You go to a facility like what Jeffries is doing right now. And if after 90 days they say, no, whoop, whoop, he's still insane, then they have to drop the charges. So, yeah. Fabulous and Retired, aka Glorious Love, said John Hinckley was here in the mental hospital, St. Elizabeth in DC, but he's out now. Tyrone, I don't know nothing about Cash Out. I don't know. I know his mama was super saved. I did watch her sentencing. She said she's in there for a reason. God has ordained her in this positioning to tell her story. And the judge still smacked her with a whole lot of years. So, yeah. Okay, so let's go on. Lindell said Anthony Weiner also didn't get charged under the Mann Act. It was a totally different situation because a minor was involved. Well, trafficking, they'll have like the trafficking, force, coercion, but then they also have the minor part of it. And that's why minor people were saying, where the minors at? Where the minors at? Well, a lot of that was because the title of the statute encompasses fraud, coercion, and force with or minors. And so people just saw minors and they was like, I've been in trial all day and I ain't heard about no little people. I ain't heard about no little kids up in here. So, yeah. Deb said you shouldn't be charged as a pimp if you're not being paid for the actual act. Man, Petty Patty, Mama Cash Out had a whole testimony service at her sentencing. And then she was talking real quiet. She was like, good afternoon, Your Honor. Judge was like, I'm going to need you to speak up. I'm gonna need you to speak up. I did watch the sentencing. I just ain't watched the trial. I'm gonna need you to speak up. She was like, okay. Oh, okay. Hold on. Okay. Speak up. Oh, Your Honor, I'm not mad. I know the judge is sitting like, we don't care if you mad or not. I'm the one that got this pen. I got the final say. I'm not mad at all. I felt like something was wrong with me because it was just weird that I didn't feel any kind of way when I was found guilty. Then I was in the chapel. And I know that God got me. I know that He got me. All right. AK says she was up there like she wasn't selling that. You know what, AK? I don't know. It's all alleged because I didn't watch it. Well, I guess he's convicted now, but it could be wrong, could be right. I don't know. Cash Out was basically hooking girls up that was down for that stuff with a higher paying customer and taking cuts. Yep, that would be a prostitution ring, Tyrone. Most prostitutes are down for that. This is their profession. It's the oldest profession. They do call it a profession. It's the oldest profession in the book. And they're usually down for it. That's why they have pimps to protect them, because they're down for it. They don't want nobody to take it from them without paying them. So if you have women that was down for the get down, and then you were taking them to meet them up with folks, and then you taking a cut out the money, like, what are we really saying? Y'all saying he innocent based on what you just said? I'm just saying this is what he just said. I ain't watched the trial. Listen, that's what she said. That's what I heard her say. Shonda Shantae, did you hear the judge? The judge was like sitting there like, can you wrap this up? I'm trying to cook dinner today for my husband. Lindell said besides the minors, they said he was spiking people's drinks, which also didn't come up during the trial. Right, that is true. What Tyrone say? Let me see. Oh, you asking him how he know that. He probably watched the trial. The trial is over. He was convicted of a whole lot. Like, he ain't getting out. He gotta die, come back to life. Then he gotta die again, come back to life, and do the last couple of years. So yeah. Brina said I did the same with the Cash Out case. I watched sentencing only. Yeah, that's all I saw. I didn't know, but I'm going by what you saying. The facts are, I don't know if that's true, but he was found guilty of everything they said he did. So, and again, I'm not one to say just because the jury found you guilty or whoever found you guilty that is necessarily true. That's not what I'm saying. I'm just saying a jury of his peers found him guilty. Generally, there's always exceptions. We accept what the jury has to say, but do they get it wrong? Sometimes they do. It's Me said Cash Out workers were also all adults and said they were forced as well and didn't receive money many times. Oh, it's Me that came up with more information. She said it wasn't always they were forced that time. And they said sometimes y'all kept the money. Mama Cash Out and Cash Out. Why he couldn't just rap? What's that song from Cash Out? I don't want to play it. I do remember one of his songs. What's the name of the song? Let me see. Y'all, we always get off on a tangent. I was trying to get out in an hour. Cash Out song. What was the name of it? Was it Cashing Out? Hold on, I think that's the name of it. I kind of know what's going on in these young people street. Let me make Yeah, that's the song. That's the song I heard. So yeah, he had a little bop going on. That was dumb. He had a little bop going on out here. You could have been okay as a rapper. Never enough, huh? Pam, did you follow the Mystical trial? Did Mystical go to trial, Dane? Did Mystical go to trial? because he's in Louisiana, and that would be a decent case to follow. He's accused of graping and all of that as well, but he was in jail for a long time awaiting trial, and different lawyers were coming out. Then I think, right, Bible. All right, now that. Let me see if Mr. Cole went to trial. They say as of March 17, 2025, rapper Mystico's grape case was delayed and no plea was entered. He in Louisiana. He been in there for a minute. Cause yeah. So it was delayed case until May 19. He faces charges including first-degree grape, domestic abuse, battery, strangulation, and false imprisonment stemming from his July 2022 arrest. Like he been in there for a minute. Authorities said the victim was distraught and had visible injuries after the alleged attack. The New Orleans rapper pleaded not guilty in September 2022. His attorneys have maintained the accusations are false. But he's had prior legal issues as well, as y'all probably know. But all right. Y'all want to finish this document? Dang, we done went off. We done talked about Mystical and Spitzer and Spicer. And all right. So Sub D, any similarly situated cases have been released on their own recognizances following the Mann Act conviction. This is what the judge wanted right here. Moreover, the cases which involve defendants similarly situated to Mr. Combs have been released on bond pending sentencing. And reviewing the cases across the country where the primary or sole conviction was for a violation of 18 U.S.C. 2421A, the defendants who were not charged with running a prostitution business have been released pending sentencing. Notably, and Trowbridge was released on his own recognizance after his plea of guilty, pending sentencing to the same offenses Mr. Combs was convicted of here. Tills similarly pled to the same offense, was also released on his own recognizance, and was given a voluntary surrender date after his sentencing, despite being sentenced to prison time. And U.S. v. Stabick, and that's the 2008 case in the Western District of New York, an associated case to Trowbridge was given a bond after his plea of guilty. Additionally, in U.S. v. Collins, and that's over there in Mississippi, probably where the statute originated from, the Northern District of Mississippi. The defendants, Mario Collins and Paulette Clayton, were charged with sex trafficking, kidnapping, violent crime, and prostitution offense. Like Mr. Combs, Collins was detained pending trial. Following a jury trial on all defenses, the court ordered a mistrial because the jury could not come to an agreement on 3 of the 4 counts on the indictment. The court ordered a mistrial, and the government indicated it would only retry the defendant on the Mann Act offense. With only the Mann Act left in the balance, Mr. Collins was released on conditions following the declaration of the mistrial. The government retried Mr. Collins and Ms. Clayton on the Mann Act offense, which is count 4, and the jury convicted the defendants of that offense. Following conviction on the Mann Act, both defendants Collins and Clayton's bail was continued. Mr. Collins was given an order of voluntary surrender post-conviction of the Mann Act offense. That case is most similarly situated to Mr. Combs. First, following a trial on the sex trafficking offense, there the jury could not agree on a verdict. The court in Collins released the top defendant. Here, Mr. Combs' jury agreed that Mr. Combs did not commit either count of sex trafficking or the RICO conspiracy. The court there released the defendants despite the Mann Act apparently being a Chapter 117 offense. Now let's go back to Collins, because apparently there's a footnote here that Collins' bond was revoked later, not because the court found the Mann Act was a Section 112 offense that mandated offenses, but rather because the defendant conceded there was probable cause that he violated his release conditions. So he was out and then he violated. Lord have mercy. Second, following the defendant's conviction of the Mann Act count on their indictment the month after the mistrial, the court continued the conditions of release and allowed defendant Collins a voluntary surrender date. Clayton was sentenced to no time. Here, following Mr. Combs' complete acquittal of sex trafficking and conviction on the Mann Act offense, the court continued the order of detention rather than allowing release conditions. However, the precedent in Collins, in a similarly situated case where there was no conviction on the sex trafficking or violence offenses, but a conviction on the Mann Act offense, provides further support for release Mr. Combs on bond. So then they say his nearly 11-month detention at the MDC is an exceptional circumstances. Sean Combs is an exceptional situation as a post-verdict pre-sentence inmate at the MDC, and his conditions of confinement at the facility qualify as an exceptional circumstances under Chavez. As the court noted in Leah, the test under Section 3145C is necessarily a flexible one, and district courts have wide latitude. Blase, blase. And the district judge, Furman, has already held that a prisoner's individual situation at the MDC can amount to an exceptional reason for release under Section 3145C. As Judge Furman noted, the state of affairs at MDC is unacceptable. In so noting, Judge Furman concluded that, quote, the conditions in the MDC qualifies exceptional reasons under the statute justifying Chavez's continuing release. That's why I said they got to a point where they was like, you know what, because of how nasty it is, he can continue being out. It's cool. He ain't did nothing yet. He ain't did nothing. So the 70-year-old defendant, that's what they gonna say, that the government is gonna talk about the age, I'm sure. The 70-year-old defendant argued that his age and various medical conditions constituted exceptional reasons, but the court found that it need not and does not decide whether that argument would suffice on its own, because it concludes that the conditions at the MDC are themselves exceptional reasons why the detention pending sentencing would not be appropriate. So they already, basically, they know the government's going to come back and say, but he was 70, he was old. And they already was like, the decision wasn't even based on his age, so don't even try it in your response. We already handled that. The same is true here, where the conditions have not improved. Judge Furman found that the conditions at the MDC are, quote, dreadful in many respects, but three warrant particular emphasis. Quote, 1, continued report of inordinate periods of lockdown. 2, claims that the facility provides inadequate or substantially delayed necessary medical care, a particular risk in this case. And 3, general issues about the conditions at the facility. These conditions have not abated in Mr. Combs' detention at the facility. As the court is aware, during Mr. Combs' incarceration at the MDC, the facility was subject to an interagency sweep that was designed to achieve our shared goal of maintaining a safe environment for both our employees and the incarcerated individuals housed at MDC Brooklyn. In other words, there's a significant issue at the MDC related to the safety of employees and incarcerated individuals that require outside law enforcement actions from multiple agencies to address. Importantly, MDC as a jail has a significant law enforcement presence within its walls 24 hours per day that are equipped with investigatory and even unregulated authority. Thus, the requirement of outside law enforcement agencies to ensure safety within the MDC is an admission that serious violence, mayhem, and chaos is occurring within the MDC that requires more than a Band-Aid raid, but rather surgery. They said, we don't need to put a Band-Aid on it. We need to tear it down and rebuild. Indeed, we are aware of ongoing threats of violence and actual violence in the facility, such that Mr. Combs' safety is constantly at risk. Here, judicial decisions from the district and our neighboring district detail the inhumane treatment at the MDC that was continued during Mr. Combs' detention for the past 11 months. See U.S. v. Colucci. That's a 2024 case just last year in the Eastern District. Judge Brown found in these issues continue to affect judicial determination. So in U.S. v. Griffin, Judge Committee granted a motion for a compassionate release based primarily on the conditions at MDC for a defendant serving time for violating supervised release. Okay. And that was US v. Santana, I guess, was their authority that provides, given the severe prison conditions that prevail at the MDC, conditions that amount to imposing harsher punishment on prisoners, this court and others have adjusted sentencing of defendants in custody there for lengthy periods. And yet another case, Judge Kogan indicated that he might have sentenced an offender to incarceration, if not for the length of the sentence, landing him in the Bureau of Prisons Metropolitan Detention Center in Brooklyn. Indeed, many courts in the Southern and Eastern District have sentenced defendants to shorter periods of incarceration or no incarceration at all due to the conditions of confinement at the MDC. Perhaps most problematic to Mr. Combs' conditions of confinement is the unchecked violence at the facility. Though Mr. Combs has been a model inmate for his nearly year-long period of confinement, the violent conditions are still very much a concern for Mr. Combs and is an unnecessary confinement risk, given the clear precedent of multiple similarly situated Mann Act convictions where defendants were released on conditions. So they said it's violent over there. A lot of you guys have said that before. So yeah, this was the same argument that Whitehead also,
You's a clown. That's what you. Why don't you call me a cardboard bishop now? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh? Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
Okay. That is Bishop Lamar Whitehead, and he raised these same arguments about the MDC, and the judge was like, "Yeah, no, remanded." I was there. Judge was like, "That sound, I get what you're saying." She just sat there just as quiet. She was remanded. He had the exact same argument as it pertains to this part. And I remember going up there, waiting on the court to open up the facility. Open up the courtroom. And I was sitting in the hallway and I was on a bench. And Whitehead, who hates my guts, he was sitting right next to me. He was talking to his lawyer. And then he was like this because he ain't want me to hear. He didn't want me to come back and tell y'all, but I wouldn't have did that. You know what I'm saying? That's attorney-client. But he was like this, trying to. And this is what he was saying. What happened is when we came up on the floor, so the elevators take a long time in the Southern District. They only got about 2 of them working. So we were waiting on the elevator for like 15 minutes and we both had to be on the same elevator. I guess he thought I wasn't going to be on there because, he was talking about me and dragging me online and stuff. So he thought, I was like, child, we both riding this elevator. So he told his attorney, like, yeah, that's that YouTuber that be talking about me on her channel. He was telling them, I'm like, hello, I'm right here. I can hear you. Now I'm not going to wait for the other elevator. So then we get on the elevator and he was standing there just all uncomfortable. I don't know. He might have wanted to reach over, you know what I'm saying? But, he was in a precarious situation. He couldn't did that to no officer of the court. He really would have did some time. So he sat there looking mad that he had to breathe the same oxygen as me while we were up in that elevator. So then we get out. And I promise y'all, as soon as we get off the elevator, you saw a bunch of marshals. I was like, oh, he going to jail. They was out there and they was like, they stood there. They were there with the little handcuffs. He was out on bond. Even after he was convicted, he was out on bond. And then what happened is, initially the government didn't ask for him to be remanded as soon as he was convicted. What the government did was they let him go out, and he was like talking about he was found guilty. He shouldn't have been. He was showing documents and stuff that he wasn't supposed to be showing. These documents you couldn't see, that was under seal. He was out there wilding on the internet trying to prove his innocence. And so the government they addressed that, but then they did the one too, like, hold on. He was just charged with something that we can get, convicted of something. We can get him under the Bail Act, which requires automatic remanding. So they filed a motion And so that's what the hearing was for. So when he sat next to me on the bench, he reached over to the attorney and was like, does this mean that I'm about to go to jail? That they're going to deny it? And his attorney basically was like, no, they don't know anything, because he did talk out loud. So he was like, no, they don't know no, they wouldn't be here for that. They don't know what's about to happen. It's like, oh, okay. You must be new here, Brody. You must be new. So we went into the courtroom, and then the judge came in. They let them do their oral arguments. And then this is how you know it don't matter what you said, because the judge already got their decision when they pick up their paper and they just start reading. In the matter of the United States versus Lamore Whitehead. Lamore Whitehead was convicted of 5 counts of A, B, C, D, E, and under the Bail Reform Act. She had a whole opinion. I said, oh, he is remanded. She got up off that bench. The marshals came from the back of the court. And that was it. That was that. And he had the same arguments with the MD. So it doesn't always work, is my point. But he had a different situation. It wasn't a low level 1 offense. He had 5 counts. It was like one of them had to do with attempted extortion or something. And that's the one that got him, because it has to do with force and violence. So when you have things that have to any like convictions of force and violence under the Bail Reform Act, apparently it's supposed to be an automatic detention after being found guilty, unless there's exceptional circumstances. So yeah. You said, how was he taking his time? He was like, he was looking at me out the corner of his eye. I was like the only one there. It might have been one other person, if I remember. It might have been another YouTuber there, but it was like empty. Wasn't nobody like stuff. He thought he was a celebrity, but definitely wasn't that many people there to check for him. He just was personally targeting me. And because Dev is from New Jersey and we there anyway, and that's, of course, across the bridge, it was like, you know what, we're going to go see some family, and then we're going to go see what Lamar Whitehead doing over here in trial. So it was just one of them situations, because he decided he wanted to be antagonistic. So I would show up at a lot of his hearings because he was just antagonistic for no reason. Like, nobody, I'm just going over your court case. I'm not attacking you personally. It's none of that. But, whatever. But he was mad because I was pulling up, like a lot of people are. If you want, like with Tory Lanez, I went through the same thing. If you only go by the facts and you go by the documents, people that want to sway the media, which is what the big networks were try to do for years, that's why Fox for being Republican or conservative. CNN or MSNBC. CNN always kind of swayed. Then you had MSNBC that was more liberal. Like that, we got our information from the media. So when you get YouTubers that are actually taking the time to investigate and not be one-sided because they don't care about neither one of you, and throw up the documents, then it debunks what you're saying. You're saying you were wrongfully convicted. You're saying you were wrongfully charged. You're saying all of this, and then I'm showing all the information that's being placed on the docket. So what I was doing was I was debunking a lot of his narrative that maybe his followers wouldn't have even paid attention to. So he hated my guts, just like with Tory Lanez. This is why the lawsuit that's going on today, it was almost expected that eventually it was going to end up happening. Why? Because I was there and people did not like me. I was a really small YouTube. I mean, I ain't big now, but I was like, shoot, I'm talking like maybe less than 10,000 subscribers at that time. So I was new. It was like my first year. I was maybe 6 months in. And so one day, me and just randomly, I was like, let's go to California to the Tory Lanez. I don't know nothing about this guy. I don't even know what songs he got. But I really do just want to, see what's going on with him. That'll be a good story to cover. So I went there and my coverage was so different from a lot of other people there because they were so pro Tory Lanez. They loved his talent, I guess. But the evidence was what it was. And I'm like, if you got evidence of what you're saying, then you need to put on a case and put the evidence there. I'm not saying that maybe they did wrongfully convict you. What I'm saying is the evidence, as the jury saw it, they had a legit reason to convict you based on the evidence that was presented. Now, y'all can come up with all this evidence that allegedly y'all found and new evidence and all of that. That's how new trials do happen. But what I'm saying is a lot of stuff I even seen them put out was evidence that was presented before a jury and they didn't care about it or they didn't consider it. The jury has the right to put weight on what they want to put weight on. They can put credibility on who they want to put credibility on. It's not up to you. So you can say everybody's lying. That ain't what the text message said. You never said that Kelsey didn't do it over in the chat. You never said you didn't mean that you did it when you was apologizing on the audio and all of that stuff. That ain't what you meant by the in the voicemail. You can say all of that. But the whole thing is that's how the government said it what meant, and the jury believed it, and they had evidence behind it for them to convict the way that they did. And so people got mad when I was like, oh, he gonna be found guilty. Like they were dragging me. I didn't know it because I don't go on station head. But apparently I learned later on that I was getting dragged for my commentary, and it was just because I was presenting it as it was being presented in court. And so it was like, oh, she's anti-black man. And I'm like, what are you saying? I'm married to a black man. Cut it out. But it wasn't that. I don't know any of these people. Why I care? I knew Meg Thee Stallion from one song and I knew Tory from no songs. Like I had to call my son, like, who is Tory? Oh, he kind of came up on the whole quarantine radio and he did the he did the whole selling, I guess, whatever, made $1 million in a minute. Like he gave me the background for me to even know who he was. But I didn't care about neither people in order to sway my opinion. Everything was really literally based on what I saw and heard there and what the jury was going to consider. So people were pissed off. I mean, that's just what it is. On the Diddy case, same way. Why he done blew up cars? Okay, but he's not charged with blowing up cars, sweetie. Like, and then the police department or the fire department said that they investigated and that they chose not to bring charges, and it's been years. What y'all want me to do? People coming out crying. He held my stuff and he treated me bad and he treated Cassie bad and he did all he needs to go to jail. Okay, well, I get it. People are in spaces of which they say they can't they weren't in a headspace in order to bring charges or they were scared of him. I'm not trying to delegitimize people's reasoning, but there are consequences to that reasoning because there's a statute of limitation and they couldn't bring it. So now you were hoping you can be vindicated through this sex trafficking and RICO that was overcharging, and it just didn't work out. It didn't work out for you. That's just what happened. You're trying to deflect, and because you didn't come forward, everybody wanted to ride on Cassie and Jane Doe's story, which just wasn't, the math wasn't math, and that's all. Thank you, It's Me, for becoming a member. Queen Shadina, thank you so much for becoming a member. We're going to get through this document in real life, for real. All right. So now we're going to get to the flight risk, okay, and danger to the community. Remember, the judge was saying he was a danger because he admitted he's a violent person. Sean Combs is not a risk of flight, nor is he a danger to the community or to any specific people. Given the undisputed facts that Mr. Combs voluntarily came to New York to surrender in this case in advance of his arrest, that he surrendered his passport to his lawyer 6 months before his arrest, and that he paid off the outstanding mortgage on his home in Miami prior to the arrest so that he would own a home free and clear to secure any bail package, and that he has now been acquitted of the racketeering conspiracy and sex trafficking charges against him, there is no serious argument that he is a flight risk. So now we turn our attention to the government's argument that the court's statement on July 2nd, 2025, that he poses a danger to community or to others due to his past violence. The court noted that the defense admitted a history of domestic violence to Ms. Ventura and that he struck Jane twice on June 2024. However, we strenuously object that Mr. Combs poses a danger to the community if released on condition. Based on the facts developed at the trial, aside from a single instance on June 18, 2024, where Mr. Combs was provoked by Jane through her own acts of violence, there was no evidence of any acts of violence in the last 7 years. Indeed, the jury notably rejected the government's argument that the June 2024 incident constituted coercion when it acquitted Mr. Combs of the sex trafficking charge in count 4. Also, Prior to his arrest in this case, Mr. Combs enrolled in a domestic violence program in which he participated until he was arrested and incarcerated in connection with this case. Okay. So he was already getting help, y'all, for his violence. The court is familiar with the trial evidence and counsel will not recite it here. The relationship with Ms. Ventura ended in 2018, and there was no evidence at trial of any physical altercation between Combs and anyone else between their breakup in 2018 and the physical altercation with Jane in June of 2024. I'm going to be honest. I felt like the court's decision to say that everybody keep hinging on this Cassie video. I did not think when it came to violence, that was a great position of the court. That I will say. When he said it, I'm like, there wasn't like even with Jane, okay? If allegedly this whole violent situation happened and he made her have sex, that would have been sex trafficking, of which he was acquitted for. So there wasn't any coercion, and the jury may not have believed that there was ever violence. That means the court would have to believe basically that there was violence. Now, he did admit to violence. Why? He didn't have a choice. It was a whole video of Cassie, but he hadn't been with her since 2018. So to say, I'm going to hold him and say he's violent, he's a violent person, even though this happened 2000, let's just say he beat her up until 2018 and it was beyond the 2016 incident, because it probably happened after that. But you're talking about 5 years. You know, some people will beg to differ and say, oh, I've seen him do this and he did this to me and all of that. But he was not charged for that. And he was not put on trial for it. So it's an allegation that you're saying against him. People that wrote letters and stuff, they were allegations. That's what it was. Even Cassie's lawyer was like, she didn't want him out, but it was so generalized. It was like a 4 or 5 liner. Okay. And regarding Jane, she testified that she started the altercation by smashing his head into her kitchen counter and threw glasses and candles at him. She did. She testified to that. Notably, Jane and Combs dated for 3 years and their relationship did not have a history of violence. There was only one incident of an alleged assault. And again, when that incident happened, Cassie had already filed her lawsuit. And so Jane testified, she read the lawsuit and she called him. And the thing that was missing from her case, that was missing from her situation, that was and Cassie's was the violence. That's what was missing. And so I do think it's kind of ironic that you decide, this woman and testified basically what she said in her complaint, that this man was beating her for years, but then you didn't get any type of those beatings, but you decide that it was a good idea to get mad and take his head and smash it against the table and think that he wasn't going to respond. And he allegedly was beating this lady like for the whole dang near 9 years, I guess they were together. So it did seem a little suspect. If released on condition, Sean Combs will not be violent to anyone. As we said in court, this jury gave him his life back and he will not squander his second chance of life, nor would he do anything to further jeopardize his 7 children not having a daddy and 4 of his children not having a parent at all. The court can fashion any set of conditions, and Mr. Combs will abide by any condition to make the court comfortable that Mr. Combs will not be violent towards any person. These are the proposed bail package. Y'all ready for this? This is what he wants to do if the court will be so inclined to let him get out. Thank you, Grace, Mercy, and Save, for becoming a member, and thank you for all of your support. I appreciate it. You've been on here, commenting and liking and all of that stuff. Cassandra said Cassie was in contact with Diddy by her own choice until 2020, after she was married with the child that she named Frankie after Diddy's alias, Frank Black. So how is she scared now? I mean, you have valid points. TJ said NBA YoungBoy has a DV incident on tape and the feds gave him bail. You hear that, feds? That's what TJ said. Let's see. Sharon said, what do I think about Ghislaine Maxwell wanting her case overturned? I actually have the, we're going to get to this bail package and we're going to wrap this up. But I actually do have, I don't know if I went over that here. I might do a separate live on that if y'all care. Maxwell, the actual document that they're fighting over. So the only issue before the Supreme Court, and that's if they decide to have full briefing, because what happens is it goes to the Supreme Court, they do their initial petition, writ of cert, and then they can reply or they could waive their reply. Them being the government, of course, they replied. And the government will look at all the documents and then they'll decide whether they want full briefing and whether they want oral arguments. So I actually read the alleged agreement that was, I'm not going to say alleged because it was filed, the agreement that was filed with Epstein. And it does say that co-conspirators and the thing was, it was a package deal. So he had a state claim and then apparently they were considering, I guess, federal claims. So it was literally a package deal. They weren't supposed to bring nothing against him, state and federal. That's how that package was. So we can go over that, what the actual agreement was that she's fighting. So anyway, her sole issue on appeal is that she was covered under the Epstein agreement. That's her sole issue on the Supreme Court. So yeah, KD said, I wholeheartedly believe that Diddy is guilty of something, but the government didn't prove their case. The detention now feels like a punishment for them losing. That's from KD Perry. He's been in there for a minute, and you have to look at the fact that he may have gotten probation for this, and he's already done a year. So yeah. So based on the exceptional circumstances set out above, we move for release on the following conditions. Combs will sign a $50 million bond secured by Mr. Combs' home in Miami. The bond will be co-signed by 3 financially responsible people. Combs will reside in his home in Miami. Combs' travel will be limited to the Southern District of Florida, the Southern District of New York for attorney meetings, as well as airports necessary to travel between the two. Defendants will be placed under the express supervision of the U.S. Pretrial Services Agency and must report to that agency as directed by PTS. And Combs' passport will be surrendered to pretrial services, and he shall not apply for any other passport. If the court finds more extreme conditions necessary, the court may also add any or all of the following conditions: home detention, private security approved by the court, and pretrial services with the cost borne by the defendant, mental health treatment, substance abuse treatment, electronic surveillance of the defendant, or any other conditions the court deems necessary. So basically, Diddy probably said, listen, let's go with the bare minimum. We'll make this negotiable. So if they have to add more so they can feel more secure, then we'll add more. But we're not about to just offer that I got to stay at home. We're not doing that this time. I already did a year over here at this jacked up, constitutionally violated facility. So if they want security that I got to pay for 24 hours in surveillance, they're going to have to ask for it. But I'm not offering it this time. All right? I'm not offering, not doing it. All right. So then in the footnote, they have Mr. Combs' homes are also equipped with electronic surveillance currently and can be shared with the PTS at their request in order to ensure compliance with any visitation policies that they set. All right. With any and all of the conditions posed above, Mr. Combs can show by clear and convincing evidence that he does not pose a danger to the community, and he will fully surrender to supervision by pretrial services to ensure that the court knows that Mr. Combs does not pose a danger to any person. So that is it. And this is him and all his lawyers. You know, the only one that I care about is Nicole Westmoreland. No, I'm joking. Alexander Shapiro, Tenny Garagos, Mark Agnifilo, you know, he the head guy. Xavier Donaldson, Brian Steele, and Anna Estavio. Okay. So this is the latest request and bid for bail. Dane said, "How long you think Cassie's husband will stick? You know what? You think he's not going to stick around? You don't think he's in it for the long haul? Think he about to try to take half of that money? What you thinking? What you thinking?" Let me see if anything else happened on this docket yet. The judge told him when they got to respond before we get off air. Let's see. The docket is so long. Nope, the judge hasn't given the time to respond. So, of course, you guys know that the judge is going to give a time of which the government has to respond, or they may just respond on their own because they was waiting on it. Because the judge, or this may be a part of when the judge also... No, because the judge asked for specific cases being turned over with their sentencing memo. So this would be separate. So, of course, the government's going to respond and say why they believe that he should remain in jail. They're going to give up. They're going to talk about the whole bail reform statute, I'm sure, and try to say why he should stay in jail. So there's that. And yeah, y'all got any more questions before we get up off this joint? Is there a hearing scheduled for this yet? No. Grace and Mercy said, if I knew my name would turn green, I would have become a member alongside. You are funny to me. Shonda Shante said, I wouldn't be surprised if he left and asked for spousal support. You know what? Southern Charisma said, just imagine a filthy rich going from luxury to the slums. You know what is crazy, though? I wonder, someone mentioned the ex-worker filing a lawsuit, and he's actually pro se, which is interesting because it seemed like somebody would have took his case because but he'd been all over the internet, so you just never know. But I wonder if Diddy and Cassie, since they're both going to be on the other side of the V together, if they're going to try to actually, their lawyers kind of connect to fight this guy. And how can she fight this guy unless she just tried to say she was the victim? Like, how is she going to try to fight this? Is she going to say everything was consensual? Or is she going to say, I was the victim just like you? It's going to be very interesting whenever, as of now, he has not served them that I saw. But we'll see shortly how this all pans out. And like I said, I believe, just like with Jonathan Odie, of course, I can't prove this, but I believe that there probably were other settlements that may have happened, and Diddy just took care of it. That's what I believe. But again, that's just speculation. All right. But we do, there was information that came out during trial that there was a settlement with one of the guys, and it was a significant amount. But they say it was based on him alleging or threatening, I guess, to release tapes that he taped that nobody knew he was going to tape, that he was going to tape them having, relations. TJ said Jane won't fight it. She want to get back together. Yeah, I don't think she will. Absolutely not. Shoot, he probably still paying her rent. You said, nah, he's gonna get out. She told him half truths, and he got more than an earful at that trial. You think so? I honestly don't believe that Cassie wanted it to go this far. I don't think she wanted him to go to prison. She certainly didn't want to testify and tell nobody guys was peeing in her mouth. I mean, come on. She certainly didn't want to, because I'm sure she knows people will look at her like, just like Jane Doe. So I don't think this was something she really wanted to do. I think she put, when he wouldn't give her that money, and honestly, he should have just paid her. And once he did not pay her, that's the reason why she filed it. And then you ended up paying her millions anyway. So it just was, once she filed it, it didn't make sense to pay her at all, because the information you were trying not to get out for these purposes of you going through what you're going through, and all these lawsuits that follow, and then your charges, of course the FBI is going to look into this. Now, obviously, it wasn't everything everybody said it was, because that's why we have the lawsuit with Ariel Mitchell, because some of the stuff was not allegedly what they say that it was. That's not what came out in trial. What people were talking about on these platforms was not what came out in trial, and now folks are getting sued. And it wouldn't shock me if other people didn't get sued. Yeah, I don't think, yeah, absolutely, she didn't anticipate having all of her personal secrets. No, but you get subpoenaed to testify. And you don't have you don't have a choice. Like, so she didn't have a choice after that because of it, and she was their quote star witness. And the thing was, what was she gonna do? Backpedal? She said in her lawsuit she felt she was sex trafficked. So if she says that she felt she was sex trafficked, then how you gonna go to the government like, nah, I was just saying that on the pleading, but I really ain't mean it though. Do you think Rule 826 will apply to Diddy sentencing? Are you talking about? Let me go to federal rules. So, criminal. Are you talking about? I think I know what you're talking about, but I ain't gonna sit up here and just act like I know all the rules off the top of my head before I respond. I don't know what that is. It's not just coming up, so I don't know. But what I will say is there is, and I don't know if this is the rule you're talking about, but there is a rule. There was an amendment to the rules of which you can't use prior offenses. So you're not supposed to use prior offenses, or, well, not prior offenses, but you're not supposed to use those charges that you were not convicted of in trying to make your decision during sentencing. So that is something that is going to, and I believe it happened in 2019 or 20-ish, if I recall. Haven't done a federal criminal case since like 2018, 17, I think. But now they have changed it where, like, because he was charged with sex trafficking and all that, the facts related to that, you're not supposed to use that against him at sentencing. But she could have kept the, you know what, Nina? Marcus said, I wonder how did the exposure of her actual acts affect her marriage. I know it could. You don't think he could have known all of it? My four girls said Pam Cassie wanted to testify because the escort was after her money. He said it was a year trying to work it out with her. She was hoping for a conviction to show her a victim. That is a good point. Okay. You know what? I do recall. That's a good point. You're so smart. I do recall, yeah, the guy did say that he had Blackburn, and he was alleging that Blackburn was trying to work it out and had sent demands, and they did not want. He's alleging that Tyrone Blackburn did not file, and he was alleging there was some type of collusion or something. It's what he was alleging, saying between Blackburn and the government, because they did not want him coming out with this lawsuit because it would have affected the way she looked as a victim. I did hear that. It's very smart. You're a smarty. Yeah, that was a good point. I like smart people. All right, y'all. I'm about to get on off of here. So you guys have a great day. We may be back to talk about Maxwell and that the document that is the subject of debate in the Supreme Court, and you can say what you think about it, whether you think that absolved her of any type of wrongdoing as well. Yeah, I know there was actually some years, like a spanning of years, so I'm not sure if those years were even within what she was convicted of, but it's interesting how they're coming out saying there's not a list, but then she was convicted of that. It's very interesting how it's going. But what we do know is folk don't want that list out, the alleged list. I I want to know what Maxwell was telling the feds last week. I need a transcript. So if anybody can get a transcript, I know it's under seal. But that'll be interesting to see the information she gave him and what additional information she would have had. Because honestly, that's something you give information so that you wouldn't have been convicted at all, or maybe you could have got leniency and testified against Epstein. But she never did that. She went away and she tried to be incognito because she has a lot of money. And she went away to live in her own little area trying to be incognito, didn't have nothing in her name. She was allegedly had the house in somebody's name. Allegedly, the bills was in somebody's name, trying to stay off the radar so they can forget about her. But then Epstein turned up unalived, and that changed it, where she was the only one they really had to snap. So I think that is why they were on her neck like that. But anyway, that's a whole nother conversation, and then we get back talking again. Y'all have a great day. Thank you so much for supporting. Make sure you hit the like button if you've forgotten. If you're new here, please consider subscribing if you enjoyed the commentary. Thank you so much.